First, I think we have a email question, if we can cue that up. This is from Lila. My mother's nursing home hires a company to take residents to appointments and things. One of her friends had a bad fall off of the bus on Friday when no one was there to help. So who should be held responsible, the transport company or the nursing home? Very good question, Lila. That seems to fall more into my arena, so I'll answer that question. And there's a and/or here. Well, very likely, the transport company, depending on how they handled that and whether they did it in a reasonable method and mechanism and whether they held up to the standard of care in that transport, will clearly be the first place that you would look in order to see if there is liability and exposure. But also with the nursing home, who ultimately has the responsibility for the care of this individual and may have negligently employed this particular company to ultimately take forth this task, and/or may have some direct roles and responsibilities from the contractual relationships they have with this person being a resident at the nursing home. So you need to look at both of those potential avenues, and that's something we'd be more than welcome to help you with if you'd like to give us a call. But that is a very sad situation. We hope you get it rectified sooner rather than later. But the issue we're really here tonight for is more directly, like we said, wills, trusts, estates, durable powers of attorney, you name it. And John, you were talking earlier about healthcare surrogates. If you would just tell the audience what that type of document is and why you would need it.
Yeah, and so I wanted to kind of take off what this email question had about the fall, and what could be coming out of that is we hope that Lila's friend there is not too badly injured and that she's going to recover. But if she was injured, and where what I can do really comes into play is helping have those documents, those legal preparations in place in case she was seriously injured and couldn't address her needs directly to her caretakers. So we're talking about maybe she's in a coma or she's just really injured and she's going under a bunch of surgeries and things like that. A health care surrogate is like a power of attorney for financial things, except it's for health care reasons. So someone you trust, usually a family member, is there. You've already talked with them beforehand. They kind of know what your wishes are as far as the extent of surgeries or care you would like. And that they are able to then communicate with your doctors and your health care providers on what it is that you want done as you are trying to recover from some of these things. Really, that's one of the main things that people don't realize, is that they only think that a will is important or a trust is important because after you die it helps to distribute your assets. A trust and those kind of things, and a health care surrogate or an advanced directives, whatever, there's a lot of different things it's called. They help you when you're just injured or incapacitated is the phrase we use, which can happen, like I said, from a fall where you bump your head, or you're going into surgery, or you have a stroke and you're limited and you're rehabbing until you can learn to speak again, and those kind of things. So they're important to have these things in place, not just as you're anticipating your final hours here on earth, but well in advance of that, because it really helps you rest easy knowing that if something does happen to you and you want to stick around, that there's going to be a mechanism in place that's going to address those, and your loved ones can do that for you.
Right. And John, you mentioned this, that gives that individual the ability and the wherewithal to provide directions while they are of sound mind, and can help their next of kin, friend, whomever they designate as that individual, and provide them guidance on what they would like to have done in whatever the particular situation they may ultimately find themselves in. But you also mentioned something about powers of attorney and the differences. If you would, something I see very frequently is folks have powers of attorney, but they may not have a durable power of attorney. And why is it significant that you need to have a durable versus just a regular power of attorney under Florida law?
Right, and so there's, Florida's unique, and I think a lot of states don't have this, but it used to be called a springing power, which only came into place when you were incapacitated or injured. Florida doesn't allow that. It's a durable power is what you want to get. You can have durable or limited. Limited is usually when you're buying a house or something like that. They have you sign a little limited power of attorney so that agent can help you do all the closing and everything. But a durable power of attorney is for your financial matters. And that comes into play hand in hand with your medical power of attorney, is what we'll call it for going forward. And because that person, usually it's going to be the same person that you asked to take care of these things for you, is going to be addressing both your financial matters. Right now we were just chatting off camera about how great the stock market's not doing. There may be some things you want to do with your money, but you're not able to do it. Your trusted advisor, your agent as it is, can deal with those things. Even in this situation with Lila's friend maybe, and Ted, you can comment on the accuracy of this, but hiring a lawyer and making those decisions would be done by a family member. And if you have that durable power of attorney for financial decisions, as well as the medical one, they can come to you and talk with you about, hey, she's in the hospital and in a coma maybe, what can we do?
Yep.